welcome. This is a nice rainy day. Thanks you all for coming out and getting a little wet to come here today. We're going to talk about wills, trust, and probate, and how to leave a legacy and not a mess. And I'm so glad that you're all here today because this is a really important topic and one that has a lot of mystery around it. You know, what do you do? Is it a will? Do you need a trust? So today we're going to maybe debunk some of the myths that you might have known, and we're going to try to help you leave not a mess, but a real nice organized plan and kind of get you started. So whether or not you just started thinking about, you know, the legacy that you're leaving in your estate, or you're deep into your plans, or you're thinking maybe you'll make some changes, this is a place for you. It's a safe place. Nobody's going to try to sell you anything today, and we are just here to help you provide education and information. And we're going to speak in general terms here. Josh is our attorney, and he's going to help you. And we won't be getting into specifics about your specific estate. But if you do have questions and you need some help with your specific questions and answers, Josh has agreed to give everybody here in the room, all of our savvy seniors, a free one-on-one consultation. So just tuck that away. A couple housekeeping things before we get started. Doug said, we are not going to take breaks because we have a lot of information to cover today. So feel free to get up, get yourself some coffee, go to the restrooms, they're right out here, and we're just going to keep plugging away here. We want to thank all of our educational partners. If you guys could just take a stand, they're in the back of the room here. They're the people, they are awesome people. Thank you so much for being here. And our education partners add a lot to our seminars. They bring fresh information, and they have oodles of information out at their table. So make sure you stop by them and visit them too. I want to introduce our guest today. We have Josh Pennerman, and Josh is a native of Nebraska, and he grew up around the Bennett area. He holds a degree in several things: psychology, sociology, and law, and an MBA focus in finance. And Josh understands how to help families with their legacy with practical, compassionate guidance. He also serves on the school board in his hometown and is a proud new dad. And that kind of helps him, gives him a personal understanding of planning for the future and how important that is. And then we have Bud Thompson, and Bud is with the Nebraska Real Estate Specialty Group. He's a certified probate specialist, a senior real estate specialist, a certified senior housing professional, and within nearly 2 decades of experience in residential real estate, and Bud focuses on helping families and estate representatives manage and sell properties after a loved one has passed. His calm approach and his deep understanding of the probate process has made him a trusted guide for many people during a very difficult time. So let's go ahead and give these guys a hand and and we have some questions, and so you guys are going to be sharing a microphone today. And I'm just going to go ahead and get started. Josh, can you just start maybe by walking us through the basic difference between a will and a trust?
Yeah, sure. So I would say a will is kind of, I guess, can everybody hear me all right?
Yeah, just hold it up.
All right. Sorry, I usually don't speak in front of groups. So wills are typically kind of like your most, I don't know, I'd say core kind of like planning document. Really what it is to pass along to state, the chance for you to state, you know, what your last wishes are, how you want your property to pass, and so forth. It really is kind of that step that you can take that gets you outside of the Nebraska intestate laws. If you die with no plan, it just becomes dictated by statute. So a will allows you to kind of just, I guess, pass property the way that you want to. Yeah. A trust, on the other hand, is a mechanism that allows us to get outside of kind of the probate process. It's sort of taken an additional step of taking your assets, your property, and so forth, funding it into a trust. That trust now holds title, and you know, there's a lot. I guess these can kind of go as far as you want, right? Like they can pass property as soon as you die, give it to your children, to your heirs. We can also set them up to be just more long-term, right? Protect assets and things down the line. So I would just say a will is kind of a more basic document. Probably the key thing that I hear a lot is like a will does not avoid probate. A trust, on the other hand, is gonna be an agreement. And just, there's a lot more that we could, I guess, get into as far as capabilities there.
Okay, good. Well, Bud, can you, I think I ran out of juice here.
Who did you?
Hello, hello? Okay, I'll speak really loud. I don't think this is working. Okay, Bud, what role then does a realtor play in setting an estate up for, or for helping families sell during probate?
Okay, well, good. She asked me the first question that she sent me. So, let's see. So, dealing with estates is an overwhelming issue for all families. I've been through it. My wife's been through it. Y'all have been through it. Incidentally, my wife's over there in the corner. She's my partner, and in real estate as well as life. And working your way through. You guys have seen this happen. I'm sure you all have. You work your way through it, and the demands are intense, and the schedules and the physical abilities that you have. You've got your life, and now you've got to take care of concluding the affairs of somebody else, a loved one of one kind or another. So where we come in is, and there's a lot of times when the people responsible for the liquidation of the estate, on television they'll call them executors. In Nebraska they call them personal representatives or PRs, and they're appointed by the court, right? More or less. The family nominates somebody probably, and
Might be in the will, or it might be,
Yeah.
if there is no will, then the family
Yeah.
nominates the court.
so in my case, and my wife's case, we end up working with attorneys refer us often. We're from Omaha, and we'll deal with the personal representative. You know, there might be 3 or 4 children involved, but we'll be working with the primary, which is the personal representative. There are times, and I've seen it, and recently we had a case where the family wouldn't touch the house for a year, and it was terribly overcrowded and dirty and beyond in disrepair. And 2 brothers that lived in Omaha just would refuse to go work on it. They actually kept cats in the house for a year. Yeah, but they went by and fed them, and they changed the box, and they water them every day. So that was not the bad part. But anyway, families get caught up in the frustration and the grief and the procrastination of the whole thing. The idea of a real estate agent that is specializing in this is to lay out a schedule and help lead them and let them work their way through a plan, which we've proven over the years is the best way to go through it. And we'll get to that part, but so that we can reduce that overwhelming feeling that they're going through. That's the main thing. And probably earn the estate a lot more money than if they were trying to do it without an attorney and a real estate person.
Okay, good. So you touched a little bit on probate, Josh. Could you tell us just exactly what probate is and how does it typically look like in Nebraska? And is it probate when you die without a will, or do you have a will and then go into probate? Can you explain all that?
Yeah, so I guess under kind of the strictest legal definition, probate is actually the act or process of proving a will. So even where we have a will, the probate process is a court process where we go in and we say, yes, this is the deceased's last will and testament. You know, there isn't evidence that they revoked it and put another one in place, or that they amended it and so forth. So it's really on its face, like probate is that, which is why, back to my point, wills don't avoid probate, they go through it. In Nebraska, if you die without a will, you can also end up in probate. We just call that kind of intestacy or just dying without a will, you'll still go through that probate process. I guess there are kind of different, there's degrees of probate, so there's formal probate, there's informal probate. You know, if we get into the formal probate, like if there's contest to the will, or, you know, children maybe fighting over it, they think, you know, mom certainly, she updated this, or that's not really what she wanted. That formal probate process can get much, much more drawn out, much more complicated, expensive, just from attorney's fees and so forth. I would say, but at a high level, the probate process, particularly if we're in the informal realm, we're gonna go find the will when someone passes away. If there is no will, we'll, you know, still file documentation with the court. As you mentioned, the court is going to appoint a personal representative that's gonna handle the estate. Maybe somebody named in the will, or just someone petitions from the family. That person will pull together, they'll start filing notices to creditors, getting notices out to interested parties, getting all the assets together. You know, they're really in charge of pulling everything together with that. They'll pay all the taxes, pay the expenses of the estate, and then ultimately we can wind up and close that. I mean, the process is gonna take, you can imagine, a few months at least, you know, probably at least 6 months on the front end, and it can take, you know, a year and a half, couple of years easily, depending on circumstances and complexities and so forth.
Wow, a couple of years, huh?
Yeah, not ideal.
Yeah,
But if you have a will, it's okay?
yes.
If you have, usually if you have a will and nobody's contesting it, yeah, we can typically be on the lower end of that, but yeah, there's always factors, right, that if somebody starts to argue about it, or if there's questions, but yeah, generally with a will, we'll shorten that timeline, but I mean, it's still a number of months, right, that you could be waiting.
Yeah. So, and Josh talked about different assets you might have in your estate. He talked about, you know, investments and real estate and personal property. But for you just deal with selling the real estate. So how is selling a home in probate different than a regular real estate sale?
I consider them projects. They have a lot of steps, and the first thing that has to happen is they have to deal with the personal property, in my book. And I always tell people, you gotta work with your lawyer to decide what you're gonna do with that personal property. And if they say get it sold, I can help find estate sale companies in the area that we work in. And actually, we're from Omaha, and we're merged now into Alicia's team here. But throughout the area, we can find estate sale companies that will help out. And then there's people that may end up cleaning out a house that's been a hoarder's house, or it might be dirty. We help with that. We help find contractors who are insured. You know, it's a very common thing that I bump into is somebody has what they call a clean out crew come, and they are just a couple people that show up, and they're friends of a guy who organized it, and they can't prove they have any insurance in case they get hurt in the house. And the lawyer can talk more about this, but it's possible that somebody could be injured in the process of moving a deep freeze or a washer or dryer out of the basement, hurt their back, and the estate will evaporate. It'll be gone in lawsuits. So that's part of it. What was your real question? I kind of forgot.
How is it different, selling a house in probate than a regular real estate
Well,
sale?
it's a project. Selling a house is a small project compared to doing an estate. I come from 30 years of being a project manager in construction, that sort of thing, in engineering. I've got a degree from a bachelor's in engineering construction management from here in Lincoln. And so I did 30 years of that, and then when I got into real estate, I thought well, real estate itself is like farming. You know, you got good days and bad days, and good seasons and bad seasons. But once I got into real estate, I saw I could use my experience, 30 years of project management, to apply it to a systematic way for people to go through the estate. So That's the big thing, is it has to be a project, and you have to help people walk through the process.
Okay, good. So, Josh, did you already discuss what the difference is between a will and a trust? I think you already touched on that a little bit. But what happens then if somebody dies without a plan or without a will, and how does that affect their family and their estate? What do they do then?
Yeah, so, again, if you die with nothing in place, we're gonna be definitely into the probate process. Really absent any formal planning, your estate is subject to Nebraska statute. So Nebraska, or kind of the way I would say, like, even if you don't have a plan, you have a plan, right? Because the state has a legal plan for you. Generally, like, we get into like the intestacy laws, it's gonna be a question of, well, if you die, if you have a surviving spouse, there's rules around, well, how much does the spouse get? That's gonna depend on, do you have children? If you have children and they're all with your surviving spouse, the split gets different. It's kind of 50-50, but the spouse gets, $100,000 up front. If you had a blended family, where you both had children from prior marriages, that split looks different. If there's no kids, if there's no surviving spouse, no kids, then we're out into your more distant heirs, right? So, I guess without doing a deep dive into that, it's really just a matter of, and if I meet one-on-one with anybody, we walk through kind of what that scenario looks like. Maybe that's something that you're fine with and something you're okay with. My suspicion is a lot of times it's not. Like, we don't like that default, and it's something we could certainly avoid and change.
Yeah, so that's a good thing to note. If you don't have a plan, the state will have one for you. And it might not be what you want to do. Can you talk to us, Bud, about some delays or issues that can occur with real estate during that probate process?
Yes, I will. Well, first of all, let's start with weather. Frozen water pipes. Somebody's got to keep track. Is the furnace set on? I've had houses where I walk into the basement and there's ankle deep water in the basement. Luckily, the floor drain was working, or it would have taken out the walls, but it ruined the furnace, etc. And it turns out the aunt of the deceased, or the sister of the deceased, was in charge of making sure it was kind of okay, because the personal representative and the decedent were in Seattle, and the sister was here in Omaha. So I went back up that particular one time. I went up and I checked to see what was going on. This was in February, March, and the thermostat was set at 60 degrees. There's a little sticky note that says, so-and-so, this is Aunt so-and-so, and I set the thermostat for 60 degrees, should be fine. Well, she didn't flip the switch from air conditioning to furnace. So the pipes were frozen, and they were spraying water all over the basement. So that's the first thing, frozen water pipes, unresolved. Another thing that'll delay a closing and the sale of a house is unresolved hail damage insurance claims. It could be that somebody was infirmed in the hospital or a retirement community for a long time. And for the relatives that are around the area, they just didn't connect that somebody better be keeping an eye on that house while their loved one is in a retirement community, and a hailstorm blows through, and nobody puts two and two together that there should be an insurance policy that is active and alive and it can apply. Buyers, I should say, most of the time when I'm selling a property, they're in disrepair and they're out of date. Most of the time, not always. There's always an exception to every rule, but most of the time they need work. And most of the time, some sort of contractor, or we call them sometimes flippers, will buy a place and will sell it to them and advertise it in the multiple listing services as is, and that's fine. People are, if they know it up front, the people that are looking for a residence immediately don't come, and the ones that want a project will come. So the first thing these guys will ask is, was there hail damage to the roof? Well, maybe nobody really knows. Well, they get an inspection of the roof and we find out there's a good live insurance policy on every house, I hope. And that, that claim fell within the time of the storm. And there can be a free roof, but that slows down the closing. Family dynamics, spats, that sort of thing. Having siblings living in different cities, I've had that where they're scattered all over the United States and they're working with a Zoom call to get all on the same page. So we've done some of that. That's mainly it. And the last one would be, if I really like the house to be empty, it's way better for the family, it's way better for us marketing and selling the house, and there's less liability if somebody's gonna steal something, or break something, or fall over something. So, to get rid of the property, you can have an estate sale company do it, or you can have it DIY, do it yourself, which is a glorified garage sale. And I'll guarantee you, every time, if you had hired a professional estate sale company, they'll bring you more money to the estate than you would have if you were out there putting tags on stuff in the garage, trying to sell it Saturday after Saturday after Saturday to get it done. And you get, eventually, when I went through it with my mom, we got to the point we were giving stuff away. We just needed the house empty. So an estate sale company is going to value things properly. They're going to advertise it properly. They're going to make you a lot more money than doing it yourself. But we get caught up in waiting for that personal property to be resolved. I think that's about it.
That's a lot. So when you think about that, those are some really good things to remember. If you're helping somebody with an estate, don't just assume, just because the house is locked up, that it's being taken care of. And as a realtor, we are facing a new kind of crisis, which are squatters. You need to make sure you check on that house. If you get squatters in there, it's really hard to get them out because they have squatters' rights now. So Josh, everybody's gonna make a plan, or they're gonna plan on making a plan. But what happens if they don't make a plan and something happens to them and they become incapacitated and they haven't designated anyone as a power of attorney? What happens then?
Yeah, so I think this is kind of a key or a very important point, right? Is I suppose at times, you know, it's easy to think about estate planning as kind of, well, what happens when I pass away? There's also the component of, well, if something happens to you and you're just incapacitated, you're not capable of making decisions, maybe for your own medical care or for financial things and so forth. So, you know, ideally, you put in place powers of attorney to, you know, that would be able to step in and make those decisions, and they're clear on kind of what you want. If you don't, if we're on kind of the medical side of things, again, Nebraska has laws on the books that sort of say like who takes priority here and who would be able to step in and make those decisions. Again, we're gonna go through, you know, spouse first, assuming they have capacity and that they're there. Then we're gonna look to your adult children, potentially back to your parents. I mean, kind of just down the line now of who those people are. I can probably name a number of times where I've seen both personally and through friends where, you know, the person that would be under statute is not the person that I would want making medical decisions for me in those cases. And then on the kind of on the financial side, it can actually get, I think, a little bit more complex because we may actually have to go into a court or something and get someone appointed to make those decisions, right? Because now we're looking for somebody that might be able to go to your bank and start writing checks to pay the mortgage or pay your bills. The bank's not just gonna let that happen because you say, oh, well, you know, they had surgery and they are in a coma, or they, you know, they were in an accident and now this, or, you know, dementia, any number of reasons, right? So, again, it's a matter of how much control you wanna take up front, and kind of name those people. If we don't, we're kind of into that, you know, state mandated, like, this is what Nebraska thinks most people would want.
So it's really important then who we choose to be our power of attorneys.
Absolutely.
Yeah, okay. Did you have a question?
Yes, could we back up a little bit to have Josh, can you explain the squatter's rights concept?
Can you explain the squatter's rights? Are you up on that?
I don't know that I'm up on it enough to speak well enough to it, but I know that it's a lot harder than it should be to remove folks at that point, but
I was
I can
showing
certainly
house,
look
yeah.
at, do you know more?
Go ahead.
You're lucky you're not in California. Yeah, it's better than that. What's that?
I stay out of there.
Yeah, and from what I've seen, I think people in Lincoln area and Lancaster are experiencing more of it than we are in Omaha, and Sarpy and Douglas County. I do know from some of the training I've had that one thing the lawyer can address this, but one thing you can do is put no trespassing signs out. In my list of things I skipped over, one of the first things I recommend is you change the locks on the house, period. Because who knows what niece or nephew that couldn't get a job or has too many, whatever, reasons, doesn't move in on you when you're not looking. I mean, when my mom, when she passed a year ago, this is in Wymore, Nebraska. Anyone? Nobody? From Wymore? Yeah, 60 miles south of here, so it was 100 miles away from us, and my sister was close by, and we have nieces and nephews that we wouldn't want in that house because we've seen them destroy other family houses. And that happens, and it happens fairly often. It could be just somebody is a smoker that moves into your house, and it goes on forever. I can tell stories forever, but I think that's just one thing I want to mention about squatters. I know that if you put up no trespassing signs, it kind of slows people down a little bit, like a speed bump.
Yeah, I mean, I would say anything that you can do to kind of give yourself more of a leg to stand on, right? Like, at least with the no trespassing, now, it's not just that someone came in and is there, now I can maybe fall back, well, I've clearly posted that this is no trespassing, so that gives me a little bit stronger case. But you're still likely gonna end up potentially litigating it and spending money on that and time and so forth, so.
Yeah. I had even one house that when I wanted to show it to a client, there was no pictures in the MLS. I called the agent. They couldn't get in to get pictures because there were squatters living in there that wouldn't let them in. So you were to buy the house as is, and your responsibility was to get the squatters out after you purchase the house. So it can get very bad, and even in Lincoln, but now we have warnings because when we're showing vacant houses, we need to be aware of some different signs that there could be squatters in there because realtors are actually being assaulted by squatters. Do you have a question?
Yeah, when does it change from a person just being a robber and the police take them away and becomes a squatter? How long do they have to be in there?
I don't know. We weren't gonna do a seminar on squatters. That's another seminar we're gonna do.
I want to say most of the squatters are related. Or maybe not all of them, but a lot of them. The ones I've seen a county sheriff's magistrate, he pulled somebody, the son of the decedent, out of the house because he just wouldn't leave. And the courts were making him leave.
So Josh, what are some of the basic documents to say we haven't started anything at all? What are some of those basic documents that we need to start with our estate plan?
Yeah, so I would say just as far as what should be included in a basic estate plan, generally I'm gonna tell you that you need a will, and then you should have powers of attorney for both like financial and medical. And as part of that medical, again, I know there are drafts that include and don't include, but as kind of part of that medical side of things, I would also include like HIPAA releases, so that people, that are making those decisions have clear authority to have your medical information released to them, as well as, I know typically people would like a living will or something that basically says, in the event that I am in a persistent vegetative state, or I, have reached a point where my doctors say I'm highly unlikely to ever recover from this, quality of life is pretty much zero, what do you want to have happen in those cases? And the living will can kind of direct that, maybe I don't want feeding tubes, I don't want hydration, I don't want invasive action taken, just, mercifully administer Medicaid and so forth. And obviously if you don't want that, then you can specify otherwise, but I'd say that's really the core of a good starting point for an estate.
I have a question question about power of attorney. When does that document become useful? I have a power of attorney for my mom and dad here, and they're still cognitively able to make their own decisions, but if I'm able to assist with them with anything, is that something I can use now and later then if there are opportunities that they're not able to make those decisions? When does a power of attorney become active, I guess?
Can you repeat that question so that everybody can hear that?
Yeah, so the question was if I have a power of attorney for my parents, when does that become active or useful? And I guess I'll kind of take twofold because I'm gonna assume you're probably talking on like the medical side.
Both.
Like, okay, yeah, so from the medical power of attorney side, it doesn't have to be this way, but the vast majority that I've seen, and I think kind of the standard is there's going to be in the event that I become incapacitated or am unable to make my own decisions, like that will be in the document. So that means before whoever your agent is, whoever holds that power of attorney, there has to first be a determination that you are not able to make those decisions. So if you're coherent, if you're able to communicate directly with your doctors, if you understand what's going on, you know, your son or daughter that has that power of attorney is not gonna come in and be able to overrule you or make decisions for you. The doctors have to effectively say, you know, well, this person is just, you know, they're no longer capable of making decisions, whether temporarily or not. That needs to make it into your medical records. And so there is kind of that threshold there. And it may be that it requires, you know, 2 doctors to sign off on it, right? I've seen people go as far as we need a panel of doctors. It's really, you know, so again, that can kind of be a hurdle. It's an important conversation and consideration as you're pulling together, you know, I guess that type of authority, the medical power of attorney. Conversely, on the financial side, most often, and those are written to where they're effective immediately. So everything outside of medical, typically you've likely just given whoever your agent is immediate rights to make decisions for you. Now, they have legal obligations, right, to not do bad things. You know, like they have to, you know, they can't just go buy themselves a new car and do whatever out of your accounts, right? But typically we would give that more immediately with the financial stuff, and that is specifically to avoid. It's one thing on the medical side, I've got doctors around, I can get someone to make that determination. Yeah, that's not the case if I need to be able to pay the mortgage and pay bills and so forth. I don't want to have to go through those hurdles. So generally, we just say those are immediately enforced. But again, you could draft around either of those.
So should the same person be the medical and the financial power of attorney, or should you separate that?
Yeah, I mean, it's gonna depend case to case, right? I mean, I think depending on who you're naming, you know, financial side of things, I would say you probably know people in your lives that you would trust with your finances, and then there's probably those people that you don't think would be all that great at it, right? The medical side, and I'd say usually the way that I kind of counsel around it, I think that can get a little trickier just because you have to remember that the people that you're designating are potentially making some hard decisions, or they're maybe not intended to make decisions, you're really just asking them to carry out your wishes. That still can be a very difficult spot for someone to be put in. And so I guess my position is where we might default to kind of like, oh, my sibling or my son or my daughter and so forth. I think a little more consideration on that makes sense because, you know, when put in that spot, are they going to be able to, you know, kind of carry that forward? You know, even if they know that it's your wishes, it's still, I've seen it be very difficult, and people do one thing and then come back, you know, minutes later or sometimes longer, you know, but occasionally things happen that you wouldn't have wanted to happen in that time. So yeah, I guess long-winded answer to it depends, and I think there's more to consider.
So it's probably a good idea to have a conversation with the people that you want to have your power of attorney so that they know what your wishes are.
Yeah.
And know that they can handle those situations.
Yeah, absolutely, and that's kind of, I think, at the core for any estate planning or really any of this stuff, the more largely where messes occur or where things go off the rails, I would say, from my experience, is just lack of communication. People end up fighting because they think mom or dad wanted this. or they were told one thing and the others weren't. I mean, that kind of goes down the line, right? Like whether we're talking about a will, or whether we're talking about powers of attorney. So yeah, communicating and making your wishes known and just having those conversations.
We're gonna hold questions till after we're done, so if you wanna write them on the back, that way we can get microphones out there so everybody can hear your questions. I appreciate it if we could do that. Let's see, for you, Bud, can you actually sell the home before the probate process is complete, or do you have to wait till you're done in probate and then sell your house? How does that work?
Yes, you can sell it early, but never without the go-ahead from the attorney. Of course, I'd have to have the go-ahead of the power of attorney, the personal representative. But I always backtrack to the attorneys to make sure that the personal representative was on the right track. So if he says or she says that I can sell it, the lawyer says that, then I'll do it. But otherwise, you could be in for a world of worms. As an example, you could end up with some conflict that shows up amongst siblings, and it doesn't happen until you're in escrow. You've got a contract and you intend to close it in the next 3 or 4 weeks, and somebody pops their head up, or some creditor pops up that really has a serious impact on the estate. And I don't practice law either, so I'm going to stop at that one. I did want to add one thing, but I'll think of it later.
Okay, so Josh, can you explain, you explained somewhat about what estate planning really is, but what if you don't have that much money and you're not that wealthy? You know, you might have a house and a car, and you might have a few investments, or you may not have any of that. Is it still important to have a will and a plan?
Yeah, I mean, I would say yes. My kind of starting point is I believe everyone should have a plan. I mean, if you're an adult, you should have a plan. Again, I think, we've kind of touched on incapacity is certainly a factor. So at least at a minimum, kind of designating the decision makers for when you can't. Perhaps if you're younger, if you have minor children, right? Even if you don't have a lot of assets, if there's minor children in the picture, having something in place so you know who would care for them, or what happens in the event that their parents or grandparent or whoever takes care of them can no longer do that. Again, anything that you build, like you mentioned, like maybe if you have a home, even if you have like modest retirement accounts, if you have life insurance, any of those things would become part of an estate, right? They can already have named beneficiary designations and so forth, but there's still money there. There's still reasons, I think, for planning and having things in place. Yeah, I mean, I guess, I don't know, not getting too much in the weeds. I mean, I really look at, I think planning can also include, I guess, more than just some of those assets and so forth. And so things like, your values, family traditions, family stories, there's aspects of that might even be outside of a will, but there are ways to pass some of that stuff on, right? Just more of a legacy aspect. And ultimately, I always come back to, in absence of anything else, do you want a judge to decide what happens to whatever it is that you do have, or would you rather make them all? Because if you do nothing at all, the likelihood of the court, or based on Nebraska statute, like that's who's going to make the decisions.
Good point, very good point. What are some of I'm gonna let you keep the mic just for a second here, sorry, bud. But I want you to talk about some misconceptions that most people have about wills or trusts or estate planning. What are some of those, or what the questions people ask you the most, and the things that they're confused the most about?
Well, certainly I think, and I've hopefully touched on this, but I think one is kind of like, well, it's only for the wealthy, or particularly if we start talking about planning that involves trusts. Like, I think there's kind of a misconception that trusts are only for wealthy people. I'd say even if you don't have a lot of assets, trusts can be a very powerful tool just for protecting what you do have or ensuring that assets are managed in a way, and passed down through the generations in a way that that might be more ideal than just going through a will. The idea that a will avoids probate, I hear a fair amount. I think we've touched on that that's not the case. Kind of people just saying, oh, my family knows what they want, or it's all gonna go to my wife and she'll do the right thing. Again, there are numerous stories out there about, blended families in particular where, husband and wife get together, each had kids from a prior marriage. One spouse passes away thinking, everything's gonna get divided down to their kids, but, now all of a sudden the rest of the family now nobody gets along, right? And spouse takes everything and they run off and they kind of hoard it or keep everything for their side of the family. There's just, a lot of things can change. You kind of never know what the future holds. And so making those assumptions, again, kind of a couple of the other big ones are really like, I have a will, I did it in 2002, right? Like, well, there's a very good chance that laws have changed, or probably your family has changed, family dynamics. There's maybe been deaths in the family or new children born. And I mean, there's so many things, right? If you've moved residences, all of those factors warrant kind of looking deeper into that. And then the last one that I'll mention, I guess, is the beneficiary designation. So you can do like transfer on death designations on bank accounts, your life insurance policies or retirement accounts can have a beneficiary designation. Sometimes those things work and do exactly what you want, right? And they can streamline things. But sometimes they also don't. Just quick example off the top of that, if you've got 3 kids and you've named one child on that bank account, again, assuming that child is gonna make sure that everybody just gets it, well, you die, that kid is now the owner of that bank account. So now it falls to them, like they have rights to it. Now, wills, trusts, stuff like that can kind of help us redirect it, but those beneficiary designations may not do exactly what we want them to do in all situations.
Do you have some kind of checklist that you give your clients to make sure they're doing all these things?
You know what, that's a great idea.
Or something. Okay, but what happens if you get a house in probate and it needs a lot of repairs, but there's no money in the estate? Has that ever happened? And if it does, what do you do?
Bottom line, simple answer, sell it as is. And there's plenty of that happens. A majority of estate houses are sold that way. There's always the exception to those rules, where we had one recently that was only 3 years old. I helped the lady buy it 3 years ago, and now she's in memory care. So her power of attorney asked me to sell it. So, it just needed a quick paint job, and the family had the money to take care of it. In a lot of cases, well, first of all, the estate sale company is gonna pull their compensation before you ever see the check for what the estate sale brought, right? It's gonna have a gross number and a net number that you get, and so they're paid up front from their labor right away. Us and other people like clean-out people, we can usually convince them to wait until the closing and demonstrate to them that there is equity in the property and it's gonna come out that their bill will be, they turn the invoice into the system, which is really the title company sort of a thing. And then the title company makes sure they're paid out of the proceeds of the house. There was a couple of quick points, and Josh hit on it, and I'm gonna put it in one simple sentence. Nothing leaves the property without the lawyer's approval. Not mine, the lawyer's. And this is the thing with like heirlooms, pictures hanging on the wall, family Bibles, all that sort of thing can create a mess. So just rule of thumb, nothing leaves the property without his approval. The other thing was, another rule of thumb, never sell a house to I buy houses for cash guy, because you're gonna lose probably 20%, maybe 30% of what you can get by putting it on the public market in a multiple listing service with an agent that's licensed and knows what they're doing. You'll always get more money because these people are basically pawn stars in a pickup truck, you know? And it's their business is to make a profit, and it is a business. So if you want more of their proceeds and you don't want to give somebody a profit, you want all of it to come to the estate, work it through the regular system so the public competes. And most of the time, we end up with 3 to 5 offers on even a fixer-upper, an estate sale that's as is, so we can always get more money. Yeah.
Okay, good. Josh, back to you. You touched on this a little bit, but how frequently should someone update or review their estate plan? And what are some signs that your will or your trust might need some revision?
Yep. So I guess what I've tried to make kind of a standard in my own practice is at least touching base every 3 years. I don't know that there's not much to that other than I know, what feels like way too long, and 3 years always seemed like it's at least likely that some material things may have changed. Doesn't mean we'd ever update stuff, or doesn't mean that we need revisions at that point. It's just kind of a checkpoint. But I would say kind of the rules of thumb or the big things that probably indicate that you should be taking a look, I would say any kind of major life changes, right? Think about, I got a divorce, there was a death or a birth in the family, maybe someone became disabled or incapacitated. Definitely if it's been over a decade since you've looked at your plan or had somebody review, or maybe if you move or buy or sell real estate, or if you're buying or selling, like starting maybe a small business or selling. Kind of those are real big things that I would say probably significantly impact it. There's probably something there that we want to at least have a conversation about.
Okay, great. Bud, are there any special disclosures that are required on a probate sale when you put it on the market? Any special things that you have to do on your end because it's in probate?
Yep. First of all, every house that's sold in Nebraska is supposed to have a seller's property condition disclosure statement, which is about a 4-page quiz with a whole lot of check marks on it. And you're checking off what the condition of the range and oven and dishwasher are, and all that, and furnace and the roof, and on and on and on for 4 pages. The exception, one of the exceptions is if you're a personal representative, it's an estate, it might be your mom, might be somebody you know, you might even have helped with some of the repairs yourself. There is an addendum which says that you're now a fiduciary and you don't really know all the details. They may, the PR may not know that it got hailed on and had a bad roof. So there is a simple 1-page addendum that eliminates the need to provide that 4-page disclosure. I've also been taught to disclose. If you know something, put it on the sheet, but then also have the addendum that says, I may not know everything, so don't come back at me. So just don't hide anything, but primarily, yes, there's a simple 1-page thing that takes the responsibility off of your back and knowing what condition the house is in.
So honesty is always the best policy. So when you talk about wills, what if I just sat down tonight and I handwritten a will? And is that valid, or what about these online forms? And what about the forms that you can pick up at Office Max? Are these valid?
Okay, so we'll start, We'll start with kind of like the handwritten stuff. In general, in Nebraska, if a will's in writing, if it's signed by you as the testator or someone signing at your direction, and it's witnessed by 2 people that are disinterested, like they're not your kids or someone that would otherwise inherit, that meets the technical requirements for having something valid. I will say if you have a handwritten will, and we're going back to like that probate conversation and formal versus informal, the likelihood especially depending on like how you try to give or pass property through that, the likelihood of ending up in formal probate is far, far higher, right? And it's more costly, more time consuming. The same thing, yeah, I heard a notary up front, and if you do those exact things, have it witnessed and signed and all that, and have a notary, that's a threshold to say, well, we have a self-approved will, right? So that really, the court will just assume like, yep, this is good, you know, all the formalities are in place. So while handwritten can be valid, I don't know that, I mean, there's probably extreme circumstances, right? Like you get stuck in a snowbank or something, and one night you just like, I didn't have this in place, and I've got a napkin in the glove compartment, you know, and you write. There could be a thing like that, right? And something like that may be upheld. As far as kind of the online or, I'll say kind of like the cheap or free online forms, I can't say for certain, but I'll make the assumption that they will be valid. Like that they at least, for the most part, they're at least gonna meet those requirements of like, yes, this is a valid will. To the extent that I've seen and reviewed things like from Rocket Lawyer, LegalZoom, some of those, I don't know, the way that I worded it to a friend of mine once was like, this basically, in my opinion, about all it does is makes you not a liar when you tell someone you have a will. They're very narrowly crafted. They're not taking into account any kind of family dynamic. They often, I suspect, are gonna miss some pretty key things that just a deeper conversation may uncover. But again, like, would it get something in place? Yes. I'm not even sure as I can go as far as it'd be better than nothing, because again, I think you could unintentionally, you know, put something in there that you wouldn't want to otherwise happen. So I'm pretty wary of it. I know there's a bunch of them out there, so I'm hesitant to say that they're all valid or that they're all this, but that's kind of the requirements, at least, to have something that would be deemed valid.
Okay. And somebody, you touched on having it notarized. So I am a notary. If anybody needs a free notary, I'll provide that service to you. But if you come with me with a will, I'm hoping that will that I notarize is just to get you in time, just to get you by until you make an appointment with somebody like Josh who can do a really thorough will and trust for you if you need that. What are some of the benefits of working with someone who actually specializes in probate real estate rather than just a regular real estate agent?
I've seen people my age try to haul things out of the house and put them in a dumpster, and they had no business doing it because their back couldn't handle it. You know, if you're gonna save time, you're gonna probably save money by not doing the estate sale yourself. You'll gain money on the estate sale. You'll save time through the whole process. A cleanout company will come in a week or two, and you and them will agree on what's gonna be donated and what's gonna be sent to the city dump. But, you know, and what goes to relatives. So that all is a good, fast process. These people are gonna go through it usually in about a week. We did have one that took a month, and it took 4 dumpsters, big dumpsters, to empty the place of junk, you know. So do you really, my age, wanna get involved in that? My back won't take it anymore. So that's a big part of it, and you're going to save the frustration and the whole sense of this overwhelming part. That's a big deal. It causes procrastination, and it speeds everything up. You just have somebody lay it out for you and help you go through it, because we do it every day. Yeah.
Okay. So what if somebody comes to you, Bud, and says, hey, I got a buyer for this house, and you know, I think we can just sell it here really quick, and you know, that way it doesn't have to go through the probate process. What would you say to them?
Give it a chance on the public market. You know, are you gonna take the first guy that walks up with an offer, whether they drove up in a Pawn Star pickup or if they're your guy? A lot of times it's the people that live next door or across the street that wanna buy grandma's house and says, oh, I'll buy that from you right now. I mean, I've heard of instances where it happened on the day of the funeral, where neighbors would come by and try to buy the house. They're always gonna probably misrepresent what the house is worth and offer way, way less than it's really worth. So what's wrong with going on the market and seeing if you can get 2 or 3, 4 offers, you know, so.
So is it okay to bypass that probate step if you know it's supposed to go into probate?
Not in my book.
Okay.
You know, and also I'm gonna add, if somebody comes and wants to sell a house and they don't have an attorney, I'll walk away, I won't take it, I won't work with them, so.
Okay. Josh, what's the role of an executor, and what should people consider when selecting an executor, and how is an executor different than a personal representative or a power of attorney?
Yeah, so, well, again, I think personal representative is probably a little bit, it is kind of the term most typically used in Nebraska. The executive and personal representative tend to be kind of interchangeable. The PR is maybe a little bit more broad term. They're different from a power of attorney in the sense that that power of attorney is typically in place during your life, so for like incapacity and so forth. The executive or personal representative is really, that's a role that we have assigned to, again, once we get into that probate process, that's the individual that's gonna help marshal assets together, you know, make sure notice is getting out to any creditors, to any heirs, any interested parties, basically, you know, paying debts and taxes on the estate, and then helping to get the everything distributed out to the distributees. Kind of the big considerations, I guess, for me, you know, I would probably, it's not always the easiest job, right? So just picking someone, you know, it is gonna be a bit time consuming. You're gonna have to, you know, obviously if there's real estate, you're working with someone like Bud, you know, you're gonna work with an attorney. So there's gonna be a little bit of back and forth there. I would say considering location, you know, if you're here and you're thinking about naming your son or somebody and they live in Texas, that might not be the easiest thing, right? Or at least make sure that they understand kind of what this might mean and what might be able to be done remotely versus in person. Yeah, and then kind of just conflicts of interest, probably amongst family members. I've been a party to certain instances where, you know, like siblings just aren't gonna get along, right? So somebody maybe names a nephew to take it through that process because we know that siblings already fight and having one over the other is just gonna contribute to that. So, yeah, I suppose those are kind of the things.
Some family members don't get along. really.
Sometimes, occasionally, not in my
That's
family.
news, isn't it?
Yeah.
Okay. Well, now I want to talk about everybody's favorite subject, the inheritance tax. What is Nebraska's inheritance tax and how does that apply? Does everybody have to pay or how does that work?
Yeah, so, yeah, inheritance tax, there's really, I mean, if you die and the people that are inheriting that property, right, as part of the estate, as settling the estate, whether we're going through probate or whether they're inheriting it through trust or whatever, the Nebraska's inheritance tax is technically a tax on the beneficiary, right? It's a tax that the person inheriting it pays, even though when we design estates, oftentimes they can be designed to where the estate is going to pay the inheritance tax kind of on behalf of that. But in Nebraska, it is technically something that's being assessed on the people that inherit the actual property. It's gonna, I guess it basically varies by degrees of relationship, right? So a surviving spouse does not owe or won't pay any inheritance tax. Immediate family, like ancestors or lineal descendants, currently it's a tax rate of 1% over the first $100,000, and that's per beneficiary. You know, so if you have a $500,000 estate and you have 5 kids, like they'd each take $100,000 that would use kind of that exemption, and then they wouldn't owe anything beyond that. We get more distance, so like aunts, uncles, nieces, nephews, and their descendants, it jumps to 11%, and the exemption's only $40,000. And then anybody beyond that is basically just 15% over a $25,000 exemption. So it's, the closer related you are, the less the burden is. And then I guess the one other point of note maybe is if we have beneficiaries that are under 22, there currently is not, we don't assess tax against basically young beneficiaries.
So if they have something that's and they're not 22 yet, do they have to pay it when they get 22? That, they're
No.
just, it's
They just,
okay.
they can just
Okay.
take, yeah.
And then what about if a house or a real estate is in a trust and it gets passed to somebody through a trust? Do you have to pay inheritance tax on that?
Yeah, so trusts don't, well, okay, I guess for terms of this discussion, I'm kind of making the assumption we're talking about like a revocable living trust, which is kind of become probably the most common estate planning method if we use a trust in our planning. Under that format, you have still retained ownership of that asset, right? You haven't given it away, you haven't done that. So when you pass away, now ownership is passing to new beneficiaries, and through that process, they're gonna pay taxes. Now, the benefit of doing it that way is they also get a basis adjustment, right? So if if the house is appreciated in value, $500,000 since you bought it, well, they're gonna take it at that new valuation, so they'll owe an inheritance tax on it, but if they turn right around and sell it, they can do so without a capital gains piece.
That's good to know. But or how do you actually help families preserve the value of an estate during that sale process?
Well, through the process, well, first of all, I'm gonna mention if you've set up an estate sale company to take care of getting the personal property sold, there's a point where you have basically said, me and the family are not gonna take anything out of the house now. We're done. The lawyers agreed what we're taking out is fine, but now from this point, when the estate sale starts doing an inventory, it's over. You don't go back in and start taking, I've seen that where estate sale companies will have something for sale one night when they close and it's not there the next morning. And some aunt, uncle, niece, cousin came and got it with the approval of the PR. It's just very frustrating to the estate sale company. Again, I'd recommend changing the locks. I did it with my mom's house. I would recommend that you do that. Make sure there's a live insurance policy in place, a homeowner's policy, because you got a lot of people walking through there, through the estate sale process and the selling process. Go back and do some research and maybe send a roof inspector out to see if that roof needs to be replaced right now. Get that done. That's just about it. Make sure you got somebody lined up to do the mowing and the snow removal. If you don't know, we can take care of getting that done for you. It's just that sort of thing.
Okay, good. What kind of assets, Josh, can actually avoid probate altogether? Are there any?
Yeah, I mean, broadly speaking, I would say that we can avoid probate with everything, really, depending on the type of planning. Most straightforward example would be trusts or through like beneficiary designations on certain types of accounts. So like life insurance, for example, that's not a probate asset. Whatever, you just designate beneficiaries and it passes that way. Bank accounts, if you do beneficiary designations, and hopefully you do it the way that you intend and exactly how you want, like that also avoids probate. You're outside of probate. The question of, I guess, whether it goes where you intended it to go is sort of a separate question. But we can certainly use, there's things like joint tenancy for real estate, passes outside of probate. And again, yeah, largely like if you use a revocable living trust, you properly fund the trust, get assets in there, you can essentially have a non-existent probate estate.
Okay, and the benefits to that, is that a financial benefit or is it just a time benefit?
Both, I mean, certainly time, but I would say largely trust estates, assuming done well, are going to be just simpler to administer, right? It's really whoever I've now designated as that trustee, they're gonna follow my instructions, they're gonna go through the trust document and so forth. Even working with attorneys at that point, if you need to kind of settle that, the process is just much simpler. You're not back and forth with the court generally and so forth, so it tends to save you both time and money.
what happens, Bud, when the property is in a trust instead of going through a probate? Is, on your end as a realtor specializing in that, is there a difference for you?
No. To me, it's whatever the attorney tells me. You know, if he says it's all right to go ahead and the personal representative is ready and agreeable, I always check with the attorney, whether it's a trust or a will, estate, or whatever. That's it.
Okay. And Josh, how is real estate handled in that probate, and what challenges arise when it involves out-of-state property?
Yeah, and I guess, but you can fill in any gaps here if you want. I would say, again, you know, we're gonna have the personal representatives gonna effectively take possession of that real estate, kind of as you've been discussing all along, right? Like we're gonna work together, make sure that we don't have those conflicts. Essentially, we gotta get to a point where we're clear and we know where it's going, that we are in fact selling the house, and then where the funds will go, or, you know, if someone is supposed to inherit the property, right? We don't wanna sell it and then later find out that somebody was supposed to get it, right? So, anyway, it's generally, yeah, the personal representative is gonna take possession and work through that administration process. Ultimately, however it passes, get a new deed recorded, whether it's a sale or if it's just passing to a beneficiary. Out-of-state property does add a little bit of complexity into the probate process. I mean, long story short, the property in another state is governed by the laws of that state. So it can depend. You know, again, you got the house in Texas. Texas law is gonna control. It probably means working with a Texas attorney, or a Texas real estate agent, potentially both. So a little more complexity, a little more cost, but it'll depend on what the laws say there.
A lot of different avenues to go through there. So, go ahead, Bud.
I just want to add one time, well, several times we've had property out of state that was part of an estate, and it's not that difficult for us in the business to find somebody through our coaching systems or whatever who is taking the same training that we've taken, that Alicia and several of us have taken, that can take care of it in another state. And the oddest one I've had so far is a shrimp boat dock in Florida. So, you know, through a network of people, like I found a guy who knew what he was doing, and also a house, an estate next to the, what is it? It's the big golf course outside of Augusta, just outside of Augusta, Georgia. So I helped the Omaha people find that agent in Augusta, but that was just a purchase. But yes, as far as the estate, it was the shrimp boat dock in Florida.
So you're the Bubba Gump of real estate now, aren't you? Okay. So Josh, you mentioned a little bit about some of these online things, and you're probably, you know, once you start Googling things about estate and estate planning, you're gonna get all kinds of things pop up and, you know, tell you how to do it yourself. What do you think about some of these online kits that you can get?
Yeah, I don't know. I think my opinion, yeah, maybe a little stronger when I get in front of people. But yeah, I guess I can't say, again, like a blanket statement, like never to use something like that. But again, the ones that I've seen, I don't know, they're very, very basic. You know, I don't think that they consider family dynamics at all. They obviously don't know you, right? They can ask questions and they can do this, but they're really not getting an understanding of your situation, your family, the goals that you may have for various things. So they just tend to not cover a lot of potential circumstances. Again, it could be, you know, I think about, again, like kids under a certain age, right? Like if you've got children or grandchildren that are 15, 16, like some of these forms are likely just gonna let them have their inheritance as soon as they turn 18, 19, right? So, you know, at 18 or 19 years old, if you would have gotten, you know, 6 figures worth of money, would you make the same decisions as you probably did in your life? You know, is that the best thing? Is that what you would want to have happen? So I think there's just a lot of circumstances that I think I would steer clear of stuff like that unless there's totally just like, you just don't have another option.
Well, we want everyone to go home today with a clear understanding of the estate planning and the whole process. What is one step that somebody in one of our attendees or all of our attendees could take to this week to help improve their estate and their plan? One step that you would like everybody to see everybody do.
I guess, yeah, if I had to list just one, it is just get started. Like, I think procrastination is probably the number one reason that people have. Most people I talk to that don't have a plan don't seem to say I don't need one, but they just say, oh, well, we should probably do that, but we haven't gotten around to it. I know it's an easy thing to just put onto the back burner and just kind of let slide. So I would say, yeah, schedule a consultation or a one-on-one, just get that conversation started, and kind of take that first step.
And when they make that consultation with you or their own attorney, what is the one thing that you wish every client knew before walking into your office for that very first time?
Probably that I don't think, it maybe feels overwhelming, or it maybe feels like, well, I don't know, or I need to have all the answers, but I would say it doesn't have to be overwhelming. You don't need all the answers, just be prepared to have an honest conversation about things, and almost guaranteed you're gonna be asked questions that you didn't consider or didn't know about, or something. There's gonna be a moment where, oh yeah, I had never thought about that, right? So it'd be impossible to be completely prepared. So yeah, don't be overwhelmed, just get started, and taking that first step, I think, helps.
Okay. Well, Josh and Bud, do either one of you have anything to add before we open it up for questions?
I'm gonna agree with Josh, make sure your first step is with an attorney. Don't try to do it without an attorney guiding you through it.
I feel like I've talked too much.
Okay, so now's the time. You got all those dying questions you want to ask. So we're going to go around with the mic so everybody can hear the question.
Do you want to touch on other properties besides a house? Farms or rental property, or, swimming pools or whatever? Businesses.
Inside of real estate, sort of like inside law and inside of medicine, if you're smart, you specialize. So if you came to me with a farm, even though I grew up on a farm, I would bring in a real estate guy a guy that does farms. And I have done rentals. Wife and I had a handful for a long time, and then we got rid of them, so I can handle the rentals. But there's specialty things. One of the things when my dad passed away is I sold his airport. It was south of Whitemore, Nebraska on Highway 77. He was a crop duster. And I sold the airport. It's not impossible, and with the family, they weren't probably gonna sue me if I screwed it up, but, we bring in specialists to help out, especially in agriculture.
This one's for Josh. You talked about the power of attorney, the financial power of attorney. You said that goes into effect, immediately. So if you have, let's say, for example, a son that you trust, but if he decides he needs a loan, he could actually take money out of one of your accounts, right?
Yeah, he would have the authority to do that. You would have recourse, maybe, right? Like you could
Yeah.
go back and say, well, you violated your fiduciary duty, essentially,
Yeah.
but yeah, he would.
Other questions? Raise your hand.
I was wondering about the no trespassing sign. Do you need to put that out in front of your house or your condo, or?
If it's Vegas.
Everywhere.
I mean, if you're living and in good health, do you need a no trespassing sign?
I wouldn't think so in that case. If you've got that and somebody intrudes and comes into your house and tries to stay without that, I gotta believe.
If it's a vacant
That's a legal, or you call the cops then.
I think we wear the dog.
There you go. Beware of dog. Yeah, survivor will be prosecuted, right?
I have two questions. The first one is,
Stand here.
I have two questions. The first one would be testamentary trusts versus revocable living trusts. Is there a difference, and when would you suggest one versus the other?
Yeah, so there is a different, I mean, a testamentary trust is gonna be, it's testamentary in the sense that it springs from your last will and testament. So you draft a will, within that will document, we might say, if when I die, my children have not yet reached the age of this, hold the property in trust, naming these people as trustee, whatever terms you want to be there. The difference with that is that trust does not actually come into existence until you pass away and we go through the probate process. So we probate the will. At that point, the trust effectively springs to life, and the personal representative will work with, whether it's the same person or if there's another person designated as trustee, to get assets transferred into that trust that's now formed, and then administer it from there. So once it's set up, it's gonna work very similar to like a revocable living trust. The main difference is that now you've gone through the probate process, that trust really doesn't exist until the day that you pass.
Is there a time limit on something like that? Is it like a year, or is it open?
It could be, are you saying like for how long that trust would exist, or how long it could?
Yes, how long would the trust exist to carry out the wishes?
That's fairly old. I mean, we could draft it we could draft it in any way. In my example of like if it were to hold property for minors, right, for grandchildren or children, if they're 5 years old at the time, certainly it could stay in existence until they, reach the age of majority. You could have it hold in trust until they were 35 if you wanted. So there's not really a time limit there. It's however we would want to draft it, we could accomplish those goals. The big distinction is just, is it a trust that we create today and fund, or is it a trust that we create in a will, but it won't actually exist until you pass and the will triggers it? Hopefully I answered your question.
TJ?
Okay, let me get back here.
If you have a farm and it goes to both kids and they don't want to sell it, who does the valuation for inheritance tax?
So to my knowledge, for the most part, we can use assessed value for, you can correct me if I'm wrong, but I think we can use that, or we could go out and hire an assessor, an appraiser, all right, to actually get that there. But I think for tax purposes, if it's just a matter of determining value and it's passed through a trust, I'm not sure we have to get it appraised.
So you want it high for capital gains when they sell it, but low for inheritance tax?
Sure, and that's kind of there's probably a trade-off there, right? Like you've got, if we know we're getting an adjusted basis, like let's get that value as high as possible. And if it's the kids inheriting and we know that the inheritance tax is 1%, like maybe that difference is, maybe that's a worthwhile calculation.
Okay, I have two questions. The first one is on probate. Okay, if you've got your trust, all of your bank accounts, you've got POD or you have beneficiaries, what is the dollar amount that, like, is it knickknacks or what, that like Nebraska has, is it 100,000 or whatever, that doesn't make you go to probate? I thought there's a dollar amount.
50,000.
It's 50,000.
So 50,000.
What's included in that? Is that knickknacks or what is that? Because if you've got your bank, your land, everything in trust, whatever, what's the probate amount?
Right. It might be nothing. I mean, you could get the probate estate to essentially nothing. Because you could also say in your trust, like you could say, I'm funding all of my personal property, all my knickknacks, all, you know, these pieces of art, this, whatever, like, I'm funding those to my trust. At that point, if there's nothing left for the probate estate, you could, that's why I say, it is very possible to get a probate estate below certainly that $50,000 threshold, but really even down to next to nothing. And then, at that point, it is just filing some paperwork, some small estate affidavits that just really, I mean, effectively eliminate the probate process.
Okay, then the second question is, I just wanna know, I kind of thought I heard you say like maybe a will, if you had a couple of people witness it, you've got your witnesses, a notary, you sign it, whatever. Okay, so what if you've worked with a lawyer, you have it drawn up, you don't wanna work with them again, so can I type a letter, have witnesses, a notary, whatever, so that when we die, this person doesn't think, oh, I'm gonna take care of their estate? Or do I just need to go get it amended right away so that we don't have to work with the person?
I guess I'm not sure if I understand the
Can
question.
you just move from one lawyer to another? Because like on our documents, like the front page of everything, it's got
Oh.
the name, the address, the everything. But if you don't want that,
Yeah.
is the only way to do it is get it amended or what?
If there's a cover page, if there's something that just has the attorneys that you work with name, that really doesn't have a bearing on the effectiveness of the will. You can certainly take it. You can, if it
Well,
comes time to settle the estate, you can work with any attorney you want.
Okay, so it's not like I need to amend it right away, because we can have our kids, as long as they know we don't want them to work with them, they can choose whoever.
Correct, yeah, the kids can choose to work with whoever, like, unless something in there says, I guess maybe not to get too specific, but unless something in there says that, like, that attorney is gonna serve as the personal representative, or like, that the attorney is named as something, nothing else would matter, it's just, your kids could work with any
Okay.
legal counsel they choose.
Okay.
I have to think too.
Great.
Good questions.
Let's get some more from Bud.
I still have the question from hers, because
Can't hear you.
I still have the question from hers, because your lawyer, you don't wanna work with anymore, and he's got all your papers, because you don't have them in your possession. And my kids would have to go back to him, even though you don't want to go back to him. So how do we amend it, saying they can choose?
Well, so, yeah, not necessarily. So, like, Bud just asked, like, is it filed with the county? I guess that's maybe just like.
I don't know that, because the lawyers never
Yeah.
said that.
I would if you contact the attorney's office, I mean, and ask for your file, they're gonna be obligated to give that information to you.
But they aren't, I mean, they don't without paying, and charging you so much, because I just want my paperwork out of there, or I want to amend something for my kids to go to someplace else.
This is something that's in place, like they just kept the original copy of your will, for example.
Yes, clear, and I've asked for it since my spouse passed away, and I'm not able to get it. I have my copy, but he says, oh, do you want me to do, because I said, no, I don't need anything done. So how do you get your paperwork?
Yeah, to my knowledge, I think we would be obligated to turn over any records upon your request. I guess I'd have to, we might have to take that offline, or if you wanna connect, maybe. To my knowledge, there would be, I mean, I guess I don't know all the rules of like ethics and stuff off the top of my head, but I think that there's an obligation to turn over those records. I mean, yeah.
So if you're the lawyer, you're my lawyer, and you retire, do you send those to like a partner lawyer, or is it my job to start all over again with someone else?
No, so I think that every attorney's office probably does it differently, right? Like my practice is not to hold on to the originals of documents. So I will store electronic copies, but for the most part, my clients, they get the originals of whatever they have. I know that's not, historically, I think it's certainly not been the practice. Like the attorney's offices held the originals, or sometimes they do get filed with the county court in the county that you've executed, right? So there's a few places that those originals could be. To answer your question, if it's myself as kind of like a solo practitioner, you know, I retire, something happens to me, I have a designated like successor attorney that would have access and of just records and like, these are my clients. So somebody that you could contact if you wanted to kind of go through, you know.
Well, I assume you'd let me know that you retired
Of
somehow.
course, definitely that, if I go out and get hit by a car.
Yeah, I just didn't know how that works, if that stays with you or how that works. Also, if I have a beneficiary like my daughter and I have on their house, does that mean that she can do whatever she wants with that house? Can she sell it? Can she keep it if she wants to?
Can you ask that, you have your daughter listed as beneficiary to receive the house?
Right, well, a beneficiary of everything, so.
Okay, yeah, I mean, typically, unless for some reason there's language or we drafted something around like, you want that house to stay in the family or something like that, or if you, yeah, I mean, if you have siblings, but if it's daughter gets everything, it's generally her choice at that point, like what she wants to do with that property.
We have time for one more question.
Okay, my question was, we went to a lawyer, we had a will drawn, and he said, oh, you don't need a trust. How do you know you don't need a trust?
Good question.
Yeah, I mean, again, I'm gonna say that I know it through, or I don't know that I know. I would typically walk through just your scenario, you know, this is kind of what your assets are, what are your goals, what kind of concerns do we have, like what does the family situation look like? And then just based on that, I'm gonna essentially try and walk you through like what things look like under whatever your current plan is, like this is kind of what would happen. Do we like that outcome or not? If we don't, like what are our other options? And so if we get to a point where the things that you want to have happen, the best or only way to accomplish that is through a trust, I mean, I guess that's how I would decide. It's difficult for me to put like an asset limit or a specific thing on like when a trust makes more sense or less sense. I've heard people put like, you know, oh, if your estate's over $500,000, right? I don't know if it's quite that simple as to just kind of draw a clear-cut line, but it is entirely possible that through conversations with your attorney that, you know, a trust didn't make sense in your current situation with kind of what you're trying to effectuate.
We're gonna do one more.
Can two people be on the medical and the financial POAs? Can it only be one legally on each one?
No, you can designate multiple potential people, and I mean, usually we'll recommend, I think, at a minimum naming some successors to say, well, you know, like I want my daughter is kind of first in line, but if she's not around or we can't reach her, here's who's next in line, right? To kind of cover that. But yeah, I think, I mean, if you wanted to give kind of, you know, competing or dual authority to do that, the trick there might be if we run into conflict, right? If they disagree, how do we resolve that? And so that's just more reason to be clear and kind of think through potential scenarios.
Okay, all right, so we're gonna move on, and if you have any other questions, like Josh said, you know, he will do a free consultation with you. And some of these things, these questions it just kind of all depends on your own personal situation. On your table should be an evaluation. There's two sides now to the evaluation, and if you could fill these out completely, we'd really appreciate that. That helps us design our seminars to make sure that they are something that you guys want to hear, and that we help you with whatever your needs happen to be. And if you want a free consultation with Josh or one of our educational partners, that's where you put this on here. They're here to provide services to you and free education and free consultation, whether it's an educational partner or not. And we're going to have the educational partners come up here, and we'll introduce them to you. And when you get this all filled out, they have some door prizes. We have a couple of other announcements. We have our game night coming up, which is September 19th. It's going to be at our real estate office. It's going to be a lot of fun. You can come, bring your friends, and just hang out and play games with each other. Our next seminar is September 3rd, and that's going to be on downsizing and decluttering your space and upgrading your life. In October, it's maximizing Medicare, and it's open enrollment for Medicare in October, so that'll be a very timely seminar. And then in November, we're talking about senior living and exploring what that would look like. And then December 3rd is going to be a real fun one. It's going to be senior stories, the power of your story. We're going to have some people here to tell their stories, and we're going to give you opportunities to tell your story too. So go ahead and fill out this evaluation.
We don't have evaluations.
You don't have evaluations? Okay. Oh, we're getting more evaluations, yeah. So that's another awesome reason why you want to pre-register, so that we'll have enough flyers for everybody. So make sure you pre-register, call, text, email. We'll also send you out an email, and I know this was kind of weird this time because we're working on our website and it wasn't working properly. So I apologize for that. We're trying to get a new person to read you on it. So go ahead and fill out those evaluations, and we'll have a drawing. And we do want to thank Josh and Bud. Let's give Josh and Bud, those are really good hands for helping us. You guys did a good job of getting the questions. Okay, so we're going to go ahead and let our educational partners introduce themselves, and then we will have our drawing.
Hello everyone, I'm Kelsey Hutchison with Oasis Senior Advisors. We are a free service for seniors and their families to use when it comes to creating a plan of care or understanding the senior living landscape that we have here in Lincoln. A lot of times we help adult children if something has happened maybe to their parent, if they have a parent in the hospital, or if they're just trying to navigate and wonder what that looks like, or maybe what their task will look like down the road. I have here a county fair basket. So we have our farm fresh eggs, our purple ribbon sourdough, some homemade jam that unfortunately it is from France, maybe their county fair, and then some popcorn as well to add, so yeah.
And my name is Kim Nesha. I'm from Caring Friends. We're an in-home care provider. We can come in, do housekeeping, take you to appointments, help with bathing, things like that. We're non-medical. We go through several territories, so if you're looking to or know of somebody that wants to stay home a little bit longer but needs that extra help, give me a call. I'm right outside here. Oh, sorry, I have a Yeti mug, all right?
Hi, I'm Rodney Heminger with Barchwell Health. This is Taylor. We are with Barchwell Health, and we are primary care providers, primary care doctors for seniors. We only see seniors that are 60 and over. A couple of questions I always ask everybody is if you spend more time in the waiting rooms than you do with your doctor, you should give us a call. If you feel like you aren't being heard by your doctor, give us a call. If you'd like to have coffee, maybe some snacks in the short amount of time you are waiting for your doctor, give us a call. We also have an activity center that's open to everybody. You don't have to be a member of us to join in that. We've got a lemonade stand coming up. We've got Singo Bingo coming up. So please, if you have any questions, give us a call. We'd love to have you. We're on 48 Minot Street. And as far as our gift today, if you didn't know, it is National Root Beer Float Day. So we have got 10 different brands of root beer and some root beer candy to give them.
And the fancy Archbold Health bag too. We would have done ice cream, but it would not have been ice cream at this point, so sorry about that, y'all.
Hello, my name is Dave Tuttle. I have partnered up with a company called American Senior Benefits. What that company does is we help you position yourself for success. And that success could come in many forms. It can come in Medicare. How many have Medicare out there, right? But how many don't understand it, right? So that's one thing we help people with. We also help people with what happens if you go into a nursing home. What do you do? Some people don't know. The other thing is what happens when you die. You do know you're gonna die someday, right? Okay, just my boss said I can only talk to people that are gonna die someday. So anyway, plus we also help you with your retirement. I mean, some of you have funds that you don't know what to do with. Well, we can help you with that. So, but the thing that we really do is we help you, and today was a perfect day. How many people out there learned something today? Yeah, I know I did. So and that's something I can pass on to the next people and so forth. And so what we help you do is position yourself for success. How many want to be there? How many don't think they're there right now? Okay, so that's all I got. My name is Dave Tuttle, American Senior Benefits, and I brought Bubba today. Actually, it's called Bubba.
Hi, my name is Reagan. I'm with the Alzheimer's Association. What we do here in Nebraska is that we do provide free programming. So if you belong to a group and you need a speaker, we can provide programming such as Healthy Heart, Healthy Brain, 10 warning signs. We have a lot of options. Some programs can be 20 minutes, they can be an hour, so it's completely up to you. If you want any more information about that, please come out to our table and you can grab my card and email me. I can connect you with our programming specialist. Another thing that we have going on right now is in less than 2 months we have our big walk to end Alzheimer's. I would love to invite everybody to come. It's completely free to register. We'd love to have you, and it's going to be at Victory Park, so that is where Aging Partners is, and the weather's going to be beautiful. I can already know that, and I hope that you can all come. Thank you. Oh, and I have a red and white basket. I don't know. I just found stuff that looked good together. So.
Hi, I'm Susan. I am with Sage Living by Tabitha. We are an independent senior living community, completely independent. Our focus is on alleviating loneliness and isolation with seniors. You may have heard of us because we are also a intergenerational community. So we have the college students that live in our community. We partner specifically with Bryan College of Nursing. So we have nursing and health science students living with us. We have a great group of students. The idea is the students intermix with the seniors. They both learn from one another, learn to understand and appreciate each other's generation, and grow together. Today I brought a nice little sun hat for gardening, walking, any other fun things. Or the beach, but we don't have a beach here.
Hello, I'm Wendy with Organized by Design. We help with relocation. So I always say that we start with the hand holding. So we'll help you go through the process of moving or even downsizing, decluttering. We help with packing, unpacking, and the idea is that the day of the move, we have everything from all the boxes, all the totes unboxed, and your picture's on the wall, the coffee is made, and your bed is made. So Organized by Design, if you're looking at relocating or just need to work on a closet or something, we are your people. I have an organizing basket because everybody needs to get organized, right? Except one person here, I think. So yes, so organize a basket with a bug and a book. So yeah, thank you.
Hello everyone, my name is Natalia Page. I am a wealth advisor with Chloe Wealth. We are a women-led financial planning firm here in town. If I look familiar, I was on the panel last month as well. We help with retirement planning, investment planning, legacy planning, and long-term care planning as well. Our office is located off 56 in Old Cheney over by the South Laszlos. I have a $25 gift card to Starbucks. My gifts will become more fancy, but this week's been a little bit chaotic, so they will get better as the months go by.
Everybody loves Starbucks. And Barb?
I'm Barb McKillop, and I'm with the Nebraska Aging in Place Council. We are a newer nonprofit here in Lincoln, and we help with aging in place. So we help find the different professionals that you might need to help you stay in your home, if you move to assisted living, to help you there, if you're downsizing, to help you there. So if you need transportation, if you need help financially, with financial services, whatever it is you might need in order to help you stay in age in place, we get you connected with the sources that you need. And I don't have anything because we had a miscommunication and we didn't bring anything.
And we have one more, Rose.
And
Get the mic.
I'm with the Savvy Seniors, and that's the founders of this, Alicia and TJ, they're founder.
You're with Nebraska Real Estate Specialty Group. We founded Savvy Seniors, yeah.
Okay, with Nebraska Realty Specialty Group, and we help people to also to help declutterize, stay in space, stay in place, or to obviously sell your homes, or whatever real estate needs you might have, you can call us with your questions.
Okay, thank you all for coming today. And all these people are amazing people. And to be an educational partner, you have to be vetted by me. And I have pretty high standards of who I let into my circle here. Because I know that their reputation is my reputation as well. And we want our Savvy Seniors to know that all these people here have said that they're gonna come, they show up, they do what they say they're gonna do, and they'll all give you a free initial consultation and explain their services to you. So should you ever need any of these services, these are the people that I would pick for myself or my own parents. So we're gonna go ahead, did everybody get their evaluation? Oh, who brought a friend? Who brought a friend that hadn't been here before? We have some treats. Hope we have enough, that's awesome. Keep bringing those friends. Wipe out that basket. Okay, and if we could get, is Josh still here? Josh, are you in the room?
Yeah.
Oh, and Bud, maybe? Okay, so you want to just pick out one of these, and the first person that comes is going to get the Oasis basket. Yeah. Ramona. Where's Ramona? There's Ramona. You get a basket from Oasis. Okay, and the second prize will be from Floyd Financial. And let's see. Go ahead and pick one, Josh. That's your job. You make a friend. Diane Peterson. Diane, are you still here? Okay. Yep, this is yours. Okay, and the next one is from Caring Friends, their basket. And Lynn Willie. Wiley? Okay, go ahead and get your basket. Go ahead, Josh, get another one. Deb Fountain. Where's Deb?
Here, right here.
Oh, that must be the lucky table today. Okay, you get Archibald. Okay, and then we have from American Benefits, Marcy and Tara. Okay. Okay, next one. Marcy, go ahead and get your prize here. Carol Thayer. Carol, where's Carol? Okay. Come up and get your prize. And then we have the one from Alzheimer's. Okay, let's see. Sharon Wilson. Sharon, go ahead. Next one, Josh. Okay, now we get the hat from Sage. I like that hat. Anybody would look good in that hat. Rita Bring. Where's Rita? Rita, okay. You get to don that new hat. And then we have from Organized by Design, the organizational basket that we all need. Sharon Kelly. Sharon?
I should pass because I won last time.
Okay. You want the basket? Okay. All right, so I think that's it today. Oh, Carol, where is? Oh, okay. Which one did you have, Carol? Was it the hat or? No, it wasn't. Okay, well, maybe it's the one who organized with design. Okay, all right. Well, thank you all for coming today. Let's give our panel a really good hand, our education department for helping us out today. We had a lot of good information. I hope it brought some clarity to you, and we hope to see you at the next Savvy Seniors. Thank you. And thank Doug, too. He forgot to get up here and talk, because he's our educational partner. And he provides our space and the